All right, now we move into part 2 of Chapter 5, and we're still discussing the civil rights. This is more focused on the rights of other minority groups, and if you see, as you see listed on the slide, we're talking about Native Americans, Hispanic Americans, Asian Americans, Arab Americans, and Muslims. The civil rights laws that African American groups pushed for have benefited members of other minority groups, such as American Indians, Asians, and Hispanics. The United States is heading towards a minority-majority status, which we have spoken to several times throughout the course of this school year. Minority-majority status is when minority groups will outnumber Caucasians of European descent. Now, if you look at this map of the United States, it shows a nation of minorities, and what I want you to focus on is the number of Hispanic Americans in this slide. Out of 105 million minorities in the population, 47 million are Hispanic Americans. That is by far the largest minority within our population as of now. Native Americans are the oldest minority group in America, but they were not made U.S. citizens until 1924. The Indian Claims Act was enacted in 1946 to settle financial disputes arising from land that was taken from Indians. And also, if you'll notice, the Indian Bill of Rights, Title II of the Civil Rights Act of 1968, applied most, not all, most of the provisions of the Constitution's Bill of Rights to tribal governments. Hispanic Americans have displaced African Americans as the largest minority group, comprising about 13% of the U.S. population. And if you look, there are two examples for Hispanic Americans in the Supreme Court. Hernandez versus Texas extended the protection against discrimination to Hispanics, and Plyler versus Doe allows public education for illegal immigrant children in Texas only. When speaking in regards to Asian Americans, the fastest growing minority group, they now comprise 4% of the United States population. During World War II, the U.S. government rounded up more than 100,000 Americans of Japanese descent and placed them in internment camps, known as war relocation centers. The Supreme Court upheld the internment as constitutional in Korematsu versus the United States in 1944, but Congress later provided benefits for the former internees, which still have not been distributed. There are more than 1.2 million persons of Arab ancestry in the United States. Since the terrorist attacks of September 11, 2001, Arab, Muslim, and Sikh and South Asian Americans and those perceived to be members of these groups have been victimized of increased numbers of bias-related assaults, threats, vandalism, and arson. The first women's rights activists were products of the abolitionist movement. The legal doctrine of coverture deprived married women of an identity separate from that of their husband. Lucretia Mott and Elizabeth Cady Stanton organized a meeting of Seneca Falls in New York to discuss women's rights. The Seneca Falls Declaration of Sentiments and Resolutions, which was signed on July 19, 1848, was the beginning of the movement that would culminate in the ratification of the 19th Amendment in 1920, which gave women the right to vote. The doldrums, 1920 to 1960, the feminist movement seemed to lose momentum after winning the vote, possibly because the vote was about the only goal on which all feminists agreed. Alice Paul, the author of the Equal Rights Amendment, ERA, claimed that the real result of protectionist law was to perpetuate sexual inequality, but most people in the 1920s saw the ERA as a threat to the family. The civil rights movement of the 1950s and the 1960s attracted many women activists. Groups like the National Organization for Women, known as NOW, and the National Women's Political Caucus were organized in the 60s and the 70s. Before the advent of the contemporary feminist movement, the Supreme Court upheld virtually all cases of sex-based discrimination. In Ree versus Reed, the court ruled that any arbitrary sex-based classification violated the Equal Protection Clause of the 14th Amendment, marking the first time the court applied the 14th Amendment to a case involving classification by sex. In Craig versus Bora in 1976, the court established a medium scrutiny standard under which sex discrimination would be presumed to be neither valid nor invalid. The Supreme Court has now struck down many laws and rules for discriminating on the basis of gender. Some of the litigants have been men seeking equality with women in their treatment under the law. The ERA was revived when Congress passed it in 1972 and granted a 3-year extension 6 years later. The ERA fell 3 states short of ratification, but losing the ERA battle has stimulated vigorous feminist activity. And as conditions have changed, public opinion and public policy demands have also changed. The traditional family role of the father at work and the mother at home has become a thing of the past. The civilian labor force includes 67 million women and 78 million males. There are 33 million female-headed households. About 2/3 of American mothers who have children below school age are in the labor force, like me. Some important progress was made through congressional legislation. The Civil Rights Act of 1964 banned sex discrimination in employment. In 1972, the Equal Employment Opportunity Commission was given the power to sue employers suspected of illegal discrimination. Title IX of the Education Act of 1972, this is important, forbade sex discrimination in federally subsidized education programs, including athletics. Title IX is not just about equality in college athletics. Please make sure you note that. 3 of the most controversial issues that legislators will continue to face are wage discrimination, the role of women in the military, and sexual harassment. The Supreme Court has frequently ruled against gender discrimination in employment and business activity. When discussing wage discrimination and comparable worth, the U.S. Supreme Court has remained silent so far on the issue of comparable worth, which refers to the fact that traditional women's jobs often pay much less than men's jobs that demand comparable skill. Median annual earnings for full-time women workers are only about 80% of those of men. If you look at the chart, which shows the shrinking gap between men's and women's wages, one thing to consider is, do you think that the gender gap in earnings will continue to shrink as your generation moves into the workforce? When speaking about women in the workforce and sexual harassment can occur anywhere, but may be especially prevalent in male-dominated occupations such as the military. Sexual harassment violates federal policies against sexual discrimination in the workplace. Although it was not a violation of federal policy when Anita Hill worked for Clarence Thomas, that would be a case to look up. It's very interesting. In Harris versus the Forklift Systems in 1993, the Supreme Court held that no single factor is required to win a sexual harassment case under Title VII of the 1964 Civil Rights Act. The law is violated when the workplace environment would reasonably be perceived and is perceived as hostile and abusive or abusive. Leaves it up for being defined. In 1996 and 97, a number of Army officers and non-commissioned officers had their careers ended, and some went to prison for sexual harassment of female soldiers in training situations. When discussing women in the military, women have served in every branch of the armed services since World War II. Women comprise 15% of the armed forces and compete directly with men for promotions. There are still 2 important differences between the treatment of men and women in military service. One, only men must register for the draft when they turn age 18. This is upheld in Rosker versus Goldberg in 1981. That's important. That's a very important test question. Statutes and regulations prohibit women from serving in combat. Now on to civil rights and the grain of America. People in their 80s comprise the fastest growing age group in this country. Since 1967, Congress has passed several laws that ban various types of age discrimination. It's not really clear what the fate of the gray liberation movement will be as its members approach the status of minority majority. There's that word again. Civil rights and people with disabilities. Americans with disabilities have suffered from both direct and indirect discrimination throughout history. The first rehabilitation laws were passed in the late 1920s. For example, the Rehabilitation Act of 1973 was twice vetoed by President Nixon as too costly, but added disabled people to the list of Americans protected from discrimination. The Americans with Disabilities Act of 1990 requires employers and public facilities to provide reasonable accommodations and prohibits employment discrimination against the disabled. Questions have been raised over whether AIDS victims are handicapped and thus entitled to protection. So far, no case dealing with AIDS victims has ever reached the Supreme Court. An image that shows Americans with disabilities that have been very active recently in demanding protection against discrimination, rightfully so. When discussing gay and lesbian rights, gay activists may face the toughest battle for equality. Homosexual activity is illegal in some states, and homosexuals often face prejudice in hiring, education, access to public accommodations, and housing. There are no positive stereotypes commonly associated with homosexuality. Homophobia, fear and hatred of homosexuals has many causes, and homosexuals are often seen as safe targets for public hostility. A substantial percentage of the American public express opposition to homosexuals entering many common occupations, though that number has been changing quickly. In 1993, President Clinton announced a new policy that barred the Pentagon from asking recruits or service personnel to disclose their sexual orientation. This is popularly known as the Don't Ask, Don't Tell policy. It also reaffirmed the Defense Department's strict prohibition against homosexual conduct. Despite some setbacks, gay activists have won some important victories. 7 states and more than 100 communities have passed laws protecting homosexuals against some forms of discrimination. Most colleges and universities now have gay rights organizations on campus. More and more states are starting to allow same-sex marriages within their states. And finally, we move to affirmative action. The interests of women and minorities have converged on the issue of affirmative action, policies that require special efforts on behalf of disadvantaged groups. Affirmative action involves efforts to bring about increased employment, promotion, or admission for members of such groups. The federal government has mandated that all state and local governments, together with each institution receiving aid from or contracting with the federal government, adopt an affirmative action program. Some groups have claimed that affirmative action programs have constitute reverse discrimination. If you look at the court case Regents of the University of California versus Bach in 1978, the court rejected a plan at the university which set aside 16 of a total of 100 places in the entering medical school class for disadvantaged groups. The court said a university could not set aside a quota of spots for particular groups. However, the court did say that a university could adopt an admissions program where race or ethnic background is simply one element in the selection process. The following year, the court ruled that voluntary union and management sponsored program was not discriminatory because the Kaiser Alumni Company's special training program was intended to rectify years of past employment discrimination at Kaiser. It is very essential to establish how civil rights policies advances democracy and increases the scope of government. Again, civil rights policies advances democracy and it increases the scope of the government. Democracy is often in conflict with itself. Both equality and individual liberty are important democratic principles, but they may conflict with each other. Equality tends to favor majority rule, but equality threatens individual liberty in situations where the majority wants to deprive the minority of its rights. Majority rule is not the only threat to liberty. Minorities have suppressed majorities as well as other minorities. Even when they lacked the power of the vote, both African Americans and women made many gains by using other rights to fight for equality. Civil rights laws increase the scope and power of government. These laws place both restrictions and obligations on individuals and institutions.